Today's panel will cover surveillance techs and the state, legal resistance to digital authoritarianism in Africa. So, as you may be aware of, or maybe not, for that we have a stand that is just outside this room. Media Defense, it's an international organization, an NGO, focusing on providing either legal help and also financial help to either journalists, media outlets, also individual communicators, citizen journalists, when they are facing like legal threats to their work, in the sense when they are facing, most of all, criminal and civil proceedings as a result of their work. Okay, so let me stress that this enough. For media defense, it is not only very important to provide you with legal help, but also with the financial help whenever you need, meaning we can cover the legal costs or some part of the legal costs of your lawyer at the domestic level if you need to. Okay? If you need further information, we will be out there and we will be happy to talk about that. Across the African continent and actually around, like all around the world, governments are increasingly relying on surveillance technologies ranging from spyware or biometric, proceeding systems that really raise serious questions on human rights. By digital, what do we understand by digital authoritarianism? Well, what we mean by digital authoritarianism is the use of digital technologies, especially by governments, to control, repress, and manipulate the population. And how do they do that? Well, they usually do that through surveillance, through censorship, or even through disinformation. Media defense considers this to be a very urgent matter to tackle. It raises a very serious new topic. We are currently dealing with more than 40 cases all around the world concerning digital surveillance. And some of the topics that we have addressed, and we find them to be like relatively new, and I hope some of my colleagues will address that, are questions like extraterritorial jurisdiction, for instance, no? The burden of proof, or what are state obligations in terms of investigating when a surveillance has taken place? I remember the case of El Salvador that's currently happening right now. In El Salvador, more than 35 journalists have been subject to secret surveillance. And the position of the state is not denying that secret surveillance has taken place. The position of the state is saying, okay, I'm going to investigate. And of course, they are not doing anything about it. And especially when it comes to a program such Pegasus, which we know that is usually only bought by states. So those are like very new topics that need to be addressed, and that's the reason of this panel today. So we are, again, very fortunate to have these distinguished colleagues from Kenya, Togo, Rwanda, and Nigeria, who will share their experiences. Just the last words on my side. Before we begin, I will just explain a few things about the format. So my colleagues, they are invited to do a first presentation that will take around 8 minutes or so. I won't be rigorous with that, don't worry. But then it's an opportunity for you to post whatever questions you have. There are also questions that have been put through the HOA app. I've already checked on them, but if you wish, if you don't want to be that public, and if you write them down, I will be happy taking a look at them through the app. And the other important thing is that from the organization, I've been asked to kindly request you, but I don't see anyone using them, to leave the headsets here in the room. Okay? So that being said, let me first introduce you to Ochiel Dudley. Morning, Ochiel. Ochiel is a distinguished Kenyan trial and appellate lawyer, an advocate of the High Court, and a regular litigator before the Supreme Court of Kenya, where he has achieved numerous landmark victories. Today, Ochiel, he will share his experience from a Kenyan perspective, as well as he will share with us some insights from the broader East African context. So, Ochiel, you have the floor. Thank you.
To come to forums like these and then hear about surveillance in places like Ethiopia, like Togo, where my brother comes from, or Rwanda, or maybe Nigeria. Until I was put under surveillance last year in June during Kenya's Gen Z protest. So I know that it's something that exists. I've felt its power, I've felt its effects on your mind. The difference between the surveillance that they do and the physical torture is just the lack of physical contact with your body. But it weighs down on your mind, it indignifies you, it intimidates you, and they can escalate it. And it's kind of interesting what they do. I mean, they manipulate the entire system. Your social media becomes theirs. They can post what they want. I mean, you see what they want you to see. So it quite heavily weighs on your mind. You cannot hear me. My voice is too low. Okay, sorry about that. I'm saying I used to come to forums like these and then hear about surveillance happening in other places, and I thought, okay, not Kenya, until it happened to me. So under physical and the digital surveillance last year. Sometimes when you're in these spaces, you're a human rights defender, you work for an NGO, you know subconsciously that your calls are not yours alone. Because sometimes you'll hear maybe a voice in another dialect, or you will call someone and the phone hangs, or your phone just overheats, and you are wondering what's happening. And so I know that the surveillance happens because it has happened to me without too many details. And it is intimidating, it is humiliating. You lack any privacy. They turn your phone and your digital devices against you. So your phone becomes their speaker and their microphone, and all your conversations, the people around you, they can describe to you what your wife, for example, is wearing on her head. It's kind of degrading what your house looks like. Anyway, so within East Africa, Kenya has now joined that league, and the legal ecosystem that allows it is similar, though different across the region, from Rwanda's proclamation on interception of communications to Kenya's cybercrime law of the Kenya Information and Communication Act to the similar proclamation in Ethiopia to Uganda's anti-terrorism law. It's done in the name of security, but then it's weaponized against opposition leaders, against journalists, against activists, and their supporters. And that becomes abuse. Maybe it's legitimate if it's used for law enforcement. The state is investigating a potential terror threat. That's a legitimate use of the surveillance software. But to use it, for example, against youth who are protesting online, against a financial bill, like the case was in Kenya last year, I think that's an illegitimate use. It's a $12 billion global market, this surveillance software. And they seem to laugh at the suggestion that we still think they're using Pegasus because Unwanted Witness did a research in June that discovered others like the likes of Sarkos, of Fisher, or something called a remote control system that makes your phone a remote access Trojan. So they can access everything within your IP address, where you are, the sounds, the people around you. And I think there's some recommendations that we could use to fight this. The first of those, obviously, is strategic litigation. But the difficulty with this thing is that it's not meant to be evident. Sometimes you don't know. Sometimes they escalate it and you know that, okay, we are watching you, we are hearing you, we are seeing you. But most times you don't know. It goes on, in the background. So you're dealing with a system that you're not meant to to see or to not, how do you evidence that before a judge? How do you turn that into your pleadings and bring it before a judge? So I think there's space for a lot of collaboration, the likes of Citizen Lab run by Access Now that checks the phones for codes, for bugs, and then you can use that to bring it forward as evidence. I think there's also need to press for oversight. In Kenya, we're supposed to have a board that oversees the National Intelligence Service. That board has never been constituted. I do not see it being constituted anytime soon. And then we can also press for legal systems that includes things like warrants. So if it's there must be something like reasonable cause, the equivalent of reasonable cause in the ordinary search and seizure, where the police, are investigating something and they have to demonstrate some cause. It's not just being done, uniformly to suppress the population or to deem activism. Perhaps I could stop there. But then at the international level, the likes of UN could try to, bring legislation. The legal frameworks that they create around the use of surveillance against activists and journalists and opposition figures. Perhaps I could stop there for now.
Much, Ochiel, for this important contribution, sharing not only your experience from the Kenyan context, but especially your individual experience. Those are very insightful thoughts. Like when you see, when you are subject to secret surveillance, it doesn't only affect your right to freedom of expression. Found that very interesting. It goes beyond. It goes to your human dignity. No, it causes such a great chilling effect. So thank you for sharing your experience. Let us now turn to Guy Valère. Guy Valère, bonjour, bienvenue. Guy Valère, he is from Togo. He's a human rights lawyer and the coordinator of CACIT's African program, where he leads strategic litigation and advocacy to protect fundamental rights across the continent. Guy, he will guide us through strategies at the regional and an international level. He will tackle the ECOWAS court, and also very interestingly, he will talk about how to use the UN mechanisms such as the individual communication procedure before the Human Rights Committee to try to, to bring forces together against this serious breach of human fundamental rights. Thank you, Guy. You have the floor.
Thank you, Marta. First of all, I'm a French speaker. If you hear about mistakes in my intervention, please be kind with me. In Togo, we have faced in 2021 and 2024 the use of Pegasus by the government to spy journalists and a member of a political party. And most of the time, the thing we can remark is that the use of the Pegasus, for example, is unproportional, because in 2021 and 2024 we don't face in this situation a protest or a contest that was very that can justify the use of the spying to spy a person like a political a person like a Catholic Church personality, for example. And in this time, we must talk about strategic litigation to fight against this digital surveillance, and this numeric authoritarianism. And first of all, I will talk about the ECOWAS Court of Justice, and after Human Rights Committee. First, ECOWAS Court of Justice is a regional mechanism that we can use to fight against numeric surveillance or authoritarianism. And the first thing we can do, we can say in this situation is that the additional protocol of ECOWAS treaty give jurisdiction for the ECOWAS court in Article 9.4 to have jurisdiction and to on human rights issues. And in that, you can bring out the human right violation in the front of this court. And something that is very important to talk about is the resources. If you want to put a case specifically in the front of this court, you must see some resources. It can be financial resources, it can be human resources, and something that is very important is to find the possibility to protect victims and to deal with the possibility of reprisal against him. And after that, we can talk about a mechanism that we can use to fight about it. It's a mechanism of amicus, for example, that give the opportunity to NGOs or CSO to provide technical expertise for the courts. And in this situation, the CSO must bring important elements about his independence, about his neutrality, and the capacity to provide this technical expertise for the court. And the second thing we can say about this situation is that in the protocol of the ECOWAS, in the rule of procedure of ECOWAS court, there's no specifically provision for amicus, but the cause has the discretionary position to granted or to denied request for amicus. And at the second level, we can make complaints. It is a request, and in this situation, you must say some element very specifically judicial procedure. For example, you must be sure in the situation to take the right strategy. First thing we can say in this situation is the ECOWAS Court of Justice is not, for example, a appel jurisdiction for the national jurisdiction. If you want to bring a human rights violation case in the front of this court, you must make sure that you will go directly, because ECOWAS Court of Justice can admit cases without exhaustion of domestic remedies. You can go directly in this. And if you make at the national level some procedures, you can change the way you must put the case in the front of ECOWAS to avoid a possibility of irreversibility of this case. The second thing we can do in the writing of the complaint is to make sure to decline the identity of the victim, for example, to make sure to bring out the violation that the victim have faced, and to make sure to analyze the violation. You can bring out the violation of Article 9 of the Charter, for example. You can bring out the violation of Article 17, if you are talking about privacy violation, for example, and you must analyze and you must request a specific demand. It can be guarantees of non-repetition, it can be compensation, and it can be, for example, a review of a law. You must be very specific in this demand. I will move to the second part of my presentation. I will talk about Human Rights Committee. And first of all, Human Rights Committee is a monitoring body to the application of the ECCPR at the national level by the state. And this body is composed by 18 aspects that make the monitoring of the application of the convention at the national level, and that make the examination of the report of a state, and that can hear individual communication if the state admit the application of the protocol, additional protocol that give the opportunity to CSO or individual person to bring out a communication in front of the committee. Thing that is important to say is we have 116 countries that have accepted this protocol, and I think for his universal scope, if we want to fight against the numeric authoritarianism, we must use this committee. And the second thing, we have the possibility to bring or to make individual communication. And this individual communication, we must talk about specific things. You must talk about you must decline the details of the victim. You must mention the state that is the author is, if I can say it like that, of the violation. You must bring out the violation of a specific article of the ICCPR, and you must analyze and bring out the situation of this violation. You must talk about the fact, and if you have evidence, you must provide this evidence in the communication. The thing is very difficult in this situation is it is very difficult to provide evidence because of the high cost of procedure to bring out evidence. And the thing we can do, for example, in the front of the ECOWAS, I will make a switch. In this situation, we can ask for the invention of the charge of proof because of the possibility for a person to provide the breach. And in this situation, in the front of Human Rights Committee, you can provide this evidence. If you have it, you must talk about the details of the violation, how it take place, for example. And after, you must talk about the national remedies, but the committee admit the cases after the exhaustion of national remedies. And this situation, they are possibilities to go directly because of in states, for example, you can have a futile remedy. For example, you can have inefficacious remedies, and you can go and explain it. And after, you can ask for a specific request. Like in the front of a ECOWAS court, it can be a review of law and things like that. And the second is the possibility to write the shadow report. In French, we call it rapport alternatif, and it gives the possibility to the committee expert to question the state about the violation of the digital right, specifically in this case, and you can use it to make advocacy to the committee member, and to make them take some recommendation. And in this situation, what you can do, what we can do, we can write the report. In the report, you can have a different session. In a session to the violation of civil and political right, we can talk about digital right, and we can make the documentation of this violation, and we can talk about the violation of this right, and after, we can make some recommendation. Most of the time, we talk about smart recommendation, and you must make this smart recommendation. And during the pre-session, you must make advocacy, plaidoyer, to the human right committee expert, to make them make some recommendation. And you can use the thing we call observation générale, to make them make this recommendation. This is what I can do about this. Thank you, Marta.
Thank you. I appreciate that you are all respecting the times allocated. So my job is easier in that sense. No, Guy, thank you very much for that broad overview of the ECOWAS and the Human Rights Committee. I found it very interesting when you were talking about protecting victims from reprisals. I think maybe in your next intervention you could follow up with that, because that's a very practical point that could be kind of interest to the audience. Also, the fact that we are allowed to submit amicus curiae to the ECOWAS court. In that sense, let me just do a little bit of publicity here. Media Defense works on it submits amicus all around the world. So if you need I don't know, if you want to submit an amicus, I don't know, at a regional level, we also specialize, especially we deal with, we are experts, let's say, from a regional and international perspective, no? So we would be very happy to do an alliance with you if you want to submit any of these amicus before the ECOWAS, I don't know, before the African Commission, Inter-American Court, European Court, any court that deals with human rights violations. Also, the use of the Human Rights Committee, the use of shadow reports. We are talking about a committee who has jurisdiction of over more than 100 countries. You would say 116 that has accepted exactly the individual communication procedure. Exactly. For me, that's particularly interesting when you are, trying to find some arguments to support your claim, because it's not only about finding communications that deal with your state, but also finding communications against other states which have similarities with what's going on in your country. So you can use the standards that have been set. I don't know, if you're dealing with a case in Cameroon, maybe you can use the standards that have been set in a case against Togo to to have to bring more arguments to the table when it comes to convincing the judge about your position. So thank you, Guy. Merci. Let us now turn to Jean-Paul Ibambe. Jean-Paul, he's from Rwanda. Jean-Paul is a lawyer and human rights advocate with over 16 years of experience in media law and freedom of expression. He has led landmark efforts such as the decriminalization of defamation, very important issue, not only in the region, but also globally, I must say, and constitutional challenges to restrictive cybercrime laws. Today, John Paul, he will share with us how the UPR, the Universal Periodic Review at the UN level, can be used as a powerful tool to resist surveillance and digital authoritarianism in Africa. So please, John Paul, you have the floor. Thank you.
Am I edible? Okay. Thank you very much, Marta, and thank you for the audience. I think surveillance is an issue because it is at some point illegal in some of our jurisdictions. So somewhere surveillance is somehow legal. There are parts of the world or our region where it is being practiced illegally, but in some of the jurisdiction, it is somehow legal. So they use means including surveillance on their daily basis. And for me, I see UPR, the Universal Periodic Review, as one of the best tools that could be used as to deal with this issue when it comes to repealing, reviewing, or harmonizing our laws in order to meet international standards, because international surveillance is not that much accepted, and if it meant to be used, there are some standards. But how are we making sure that the provisions that are making surveillance illegal in our countries are somehow meeting standards? So I see UPR as one of the best tools, and I'll mention why. The reason why, firstly, it is because UPR is universal. So each country globally has its turn of being reviewed under the UPR framework. So that means if we are having a country X or Y that is having the provisions that are allowing surveillance illegally and unproportionally, so UPR is an opportunity to review and recommend that country so that such provisions or policies being repealed or reviewed. Secondly, I might say UPR is inclusive in a way that they are not countries. Each country, yes, the country has the obligation to report on how it is meeting the standards, the human rights, but civil society, journalists, stakeholder, what we call them stakeholders, they are also allowed, or they have room to come up with. My colleague was talking about shadow reports, the alternative reports. So to assess the country, how the situation within X country, and report through stakeholders submission opportunity, and assess and recommend what they think could be done. Thirdly, it is how the UPR mechanism is designed. It's a kind of commitment, and for a country, especially those countries that have been resisting on basis like sovereignty of the state. So because under the UPR, the process is like commitment. And if a country is committed after given like the recommendations, if the country is committed to go back and implement the recommendations that it has accepted, the implementation will be somehow satisfactory, because it starts with commitment by the state itself. That means implementation or putting into place the recommendations that have been accepted is going to be high, as opposed to when probably you are just given recommendations and there's no that kind of commitment. But because UPR start with country accepting some of the recommendations and going back and implement those, so the level of implementation is satisfactory or promising. Now, the issue is probably how or if all the recommendations that were accepted by those countries are going to be implemented. Of course, there will be an opportunity to assess the country during the next review, but in between the previous review and the next one, I think that is where we are having like a great role or something to do, as to push to see countries implementing what they have committed to do during the past reviews. It is our job to do advocacy, engaging, because engaging is very important, because I will talk about, I mean, if I refer to my country, Rwanda, if you want something to be done or implemented, you have to engage, because at the end, of course, because you, let's say you are from the civil society, so you do not have powers to enact a law. It is the government who's going to enact the law to change all those provisions. So if you do not engage the state, the government, as to tell, please, you have, during the past review, you have accepted to repeal XYZ provisions. Now, 1 year to the next review, where are we? So are you going to, as a government, are you going back and saying, no, we've failed to do this? So when you engage, at some point, so they say, okay, we need probably to do something so that our level of implementation be improved. So you might not have like a full implementation of the recommendations, but at least there will be an improvement or number of provisions that are, recommendations that are going to be implemented. So if I give an examples on how UPR is working, I will start with Rwanda. We've seen so many revisions of our laws. For example, defamation was partially I say partially decriminalized because we still have some elements of defamation in some of the laws, but the little we have, it was because of the commitment the government has made before Human Rights Committee during the Universal Periodic Review. Other countries like Senegal, South Africa, the Gambia, they have been repeating some of their provisions, including decriminalization of defamation, for example, because they have accepted to do something around those provisions during Universal Periodic Review. I think I can stop by here, then my colleague continue.
Very much, Jean Paul, for sharing your experience and your thoughts. Indeed, you were initially, like at the beginning, you were talking about the legality aspect of secret surveillance, and the thing is, secret surveillance can be legal. It can be. There is no problem with that. It can be in our legislations. The thing is, like according to international standards and to constitutional standards, it must comply with other requirements, okay, such as the pursuit of a legitimate aim and being proportional to that legitimate aim that is pursued. And that, I think, it's our job as civil society to be that, like, to act as this oversight mechanism, and to fight that back, because of course what we see currently, it's an undue use of secret surveillance all around the world. I agree that the UPR can be a very powerful mechanism also to I always say that the UPR is that way to shaming states, no, to shaming states, other states talking to each other like at the same hierarchy, or well, at least they try to be at the same hierarchy. They are supposed to be at the same hierarchy, and they are shaming each other for not complying with human rights. But that's the thing. It's a thing about what's the mainstream narrative right now. Like, the mainstream narrative is the violation of human rights is wrong. But what about this? This can shift. What about there are certain people thinking that human rights violations are not that important as long as I have security and as long as I have economic growth in my country? It can happen, and it has happened. We can see that in many countries where human rights are not as important as they used to be. So that narrative needs to be, again, defended in order for states to be ashamed at the UN level, at the UPR mechanism. So thank you very much, Jean Paul. Our next speaker, my colleague Tsema Yvonne Ede from Nigeria. Tsema is a lawyer and policy expert with wide-ranging experience in human rights, governance, and gender, having worked with governments, civil society, and international organizations to strengthen accountability and protect citizens' rights. She has also led initiatives supporting human rights defenders and promoting inclusive governance through feminist leadership platforms. So, it was funny because at the HOAP, I already checked some of the questions that were posted there. And Charles Donaldson from Uganda, he submitted a question on how states can be held accountable for the misuse of surveillance technologies. And the reason I'm laughing is because we were talking yesterday about this panel and what was the issue that Tsema was about to tackle, and it's exactly that topic. So, Tsema, you have the floor. Thank you.
Hello, can you hear me? Good morning, everyone. I think I want to start this panel with a story of somebody, a regular guy in Nigeria. His name is Solomon Akuma, just a regular guy using Twitter, X, and he was a student at that time, and he posted something on Twitter which was an insult to the president at that time. and the state used surveillance tactics to get him. Just a regular guy. The state started with, they found his pastor, they found his father was a pastor, found how to reach his father, looked for where he lived. Somehow they found him and they used his father to get him. He was in detention for 9 months before he was tried. Before he was charged to court, he was charged for sedition, treason, and threatening to kill the president. He was now in detention for 33 months in total before the Court of Appeal dismissed the charges against him. And so you say to yourself, surveillance doesn't affect me, so to speak, but it comes down to the fact that it's as granular as the regular guy in a village. And it wasn't even in the state capital, the country's capital. It wasn't in commercial capital. It wasn't a buzzing state. It was just a regular guy using X. And so we say, where does your freedom of expression? Freedom of expression has limits. It has limitations. People should not use social media anyhow. But that is a problem. And like Marta said, it creates a chilling effect. And often 33 months of that guy's life is lost. The case was dismissed. He's relieved to be out of detention, but is the state going to be held accountable for the way he was treated and the fact that it took 33 months out of a person's life? No. And that itself is a problem, because that is what allows for impunity. And we all know that according to the law, states have international human rights principles. States have positive and negative obligations towards citizens. The negative obligation is not to engage in, tolerate illegal, arbitrary, or disproportionate surveillance. That's their negative obligation towards us. Their positive obligation is to ensure that they have regulations in place that actively protect citizens and oversee the use of surveillance technology. They don't do that. And Marta had said earlier about the tests that are needed for states to be able to use certain surveillance technology, which is the legality, proportionality, legitimate aim, and necessity. And we find that states do not care about all of this. They just go in there and they just jump into doing the things that they do, which affects how we engage with the system, and Ochiel spoke to privacy and how that strips you of dignity. And the African Charter provides for that. The ICCPR provides for our right to privacy, our right to dignity. While the African Charter doesn't necessarily speak to the right to privacy, it speaks to dignity and our inherent human dignity, which can be translated to our right to privacy and our right to express ourselves. And because human rights are interconnected and interdependent, you find that when the states violate your right to privacy or your right to expression, they violated other rights. Like with Solomon, they now took his right to freedom of expression, they took his right to privacy, they also took the false arrest and the false accusations, and it becomes a wide range of rights abuse. And we need to hold states accountable. Luckily, we have these mechanisms, like they've all spoken to, that hold states accountable. But is that enough? Maybe not, because we also need to engage with the system. So when the Court of Appeal dismissed the case, the sad thing was that we didn't take it further by probably engaging in strategic litigation that defines to what extent can states engage in surveillance. And so another conversation is, was there judicial oversight? Was there a law that said, okay, even when you said, okay, this person was threatening the president, was there some sort of judicial oversight that said, oh, this is how you should go about it? Was there a judge that allowed you go about that surveillance? No. Was there proof that a crime was being committed? No. Was there proof that a crime will be committed? No. They just felt like they needed to intimidate the citizen. And that is what creates a chilling effect. It doesn't allow whistleblowers to speak because you don't know who your sources are. Journalists are in trouble. And so it can't even allow for good governance. And we already have all these mechanisms within the African Charter and the resolutions that say these are the means we must hold states accountable, and we're not utilizing it enough, I think. And I think a good way to start, I'd like that she said naming and shaming them using the UPR, but we also need to engage in the litigation processes. And most times, social media hashtags is what helps people. Hashtag Free Solomon Akuma, hashtag every day there's a new hashtag when it comes to rights protection. And how do we ensure that the states are held accountable beyond hashtags? Is that we must use the laws against them. And the laws are very, very specific. It's our job to always engage the states on these things, and also the private sector actors as well, the non-state actors that they use to engage on these means. Are they allowed? Is there a law that won't allow them buy all that surveillance tech? $12 billion was said to be spent on buying surveillance tech in Africa. And Nigeria happens to be the hugest consumer of surveillance tech. Is there a law that allows you to spend that much money? What was the budget process? So outside of all those things, there are other small loopholes and opportunities that we can leverage on with even the way they even buy surveillance tech. What does the budget process say? How does the law allow you spend that kind of money? Because was there judicial oversight? And so those are the kind of things that we need to interrogate when ensuring that states are held accountable for surveillance and digital authoritarianism. To what extent? Why is a regular guy who is in university being surveilled like a terrorist, and you now accuse him of terrorism and sedition? He's lost 33 months rather of his life. Where do we go from here? How do we ensure that even if this disaster and this human rights violation has occurred, how do we make sure that the state is held accountable for that? I think it is by using lawsuits. We definitely have to engage the courts on the lawsuits. We also have to get the courts to define to what extent can they do this. In the Solomon case, it was interesting how a judge had to recuse herself, in the High Court judge had to recuse herself. Then somebody else started the case, which meant that the case had to go de novo. And this is just somebody, and every time they came and they asked for bail, the bail was refused, and he was in detention for 33 months because of it ex post. And some of us will say to ourselves, oh, maybe we shouldn't post so we don't lose 33 months of our lives. That's self-censorship. That's dangerous to democracy. That's dangerous to the process. And so the African Commission has been very, very clear on that. And it says that states must align their surveillance practices with international human rights law and standards. So I think the number one way we can hold states accountable is when they violate international human rights law and standards. Let's hold them accountable by that. Let's engage the litigation process, because I think that's the only way we can do it. Use existing laws, use existing processes and resolutions, and even the declarations on freedom of expression in Africa, to ensure that we tell them this is how you can do it. And we've seen that the African Commission, the African Court, and the ECOWAS Court has been very successful in defining some of these terms for states. And oftentimes when they give their judgment, it ends with states are encouraged to put processes in place that protect human rights. States are encouraged to put systems in place that ensure that this right to freedom of expression is not impugned or infringed or violated upon. And so that I think that is I will end with saying that when we find that international human rights laws and standards are violated because of surveillance, because naturally they are, let's engage those systems and ensure that states in every way means possible are held accountable. Thank you, Marta.
With the detention, with the possibility of being sentenced, I don't know, sometimes they are like 2 years, 3 years, 10 years sentences. So it creates a chilling effect, even though in the end, that person is finally acquitted. Of course, positive and negative obligations of the state. The state has not only the obligation not to interfere with our human rights, but also to protect us from third parties, to protect us from the government itself. And And also the fact that I found it very interesting. I also agree with you when we talk about secret surveillance. It's not only about freedom of expression. It's also about, like in the case of these regular citizens, we are talking about freedom of expression. We are talking about right to liberty. We are talking about right not to be subject to human treatment, for instance. So yes, that all create a huge chilling effect. And I was thinking about the regional and international standards on insulting the president or insulting your flag. Please, yes, maybe be careful in your countries, but just be aware that under international standards, you are allowed to insult the president of your country. Just please don't take my word so seriously. Just this is only for academic purposes, and it's like, or if you do that, you may flee from your country. And no, I'm kidding. But just be aware that this is how it should be. As long as they are public figures, our international standards from the Inter-American Court to the European to the African system, they tell us that freedom of expression is not only about like saying positive things about the state, but also things that shock and disturb. So that's that's a classical standard at all regional levels, also at an UN level. So please be aware of that, at least from an academic viewpoint. And when you are challenging laws, when you are representing your client. And the last thing I was gonna say is the message you were sending about impunity. No, when like her topic was how can states be held accountable, but Tsema also tackled the necessity of states being held accountable, because if not, there is impunity. And what happens when impunity takes place? It sends a message. And that happens also with gender violence and with violence against journalists that don't get investigated. It sends a message that those crimes are okay. They can be committed. Nothing will happen. So it's very important to hold states accountable for that. So thank you very much. Thank you very much for to our panelists for their insightful interventions. As I said, I reviewed the questions that were posted through the HOVA app, and many of them, I think they have already been tackled by you, because they dealt with what were the safeguards against the misuse of surveillance technologies and the role of international and regional human rights mechanisms and their compatibility with human rights standards. So I think we are good with that. So I will now proceed to give the audience the possibility to pose questions to our participants. Yes? We have Henry over there. Can we pass him?
Thank you. My name is Henry Mulenga from Zambia, Chapter 1 Foundation. Just wanted to contribute to Tsema's point to say that I agree with what she said entirely. There's a tendency in most African countries to abuse these laws, especially on ordinary citizens. One of the examples, and I must say there are quite a number of people who have been arrested on the premise of insulting the president. In Zambia, the law on defamation of the president has been decriminalized or repealed, but we still have other laws that still follow citizens. So, for example, we have criminal defamation. In the new cyber legislation, we still have provisions where people are arrested for their speech-related offenses and sent to prison. There's an example of a gentleman in Zambia. He tweeted, so his tweets, just an ordinary citizen, so he tweeted something like, on the issue of mili meal, which is mili meal, we staple food for Zambia, comes from maize. So he said at that time there was shortage of mili meal. So he said that a bag of mili meal trading at something like maybe 320 something kwacha. Then he said Captain Solo wouldn't let that slide. So Captain Solo was a military personnel in our history in Zambia who attempted a coup. Okay. Then the other tweet said our democracy is being taken for a joke. Okay. it is time for our men and women in uniform to stand up and defend Mother Zambia. This is an ordinary person, and he was charged with an offense in our penal code, which is called inciting to mutiny. The provision reads, a person who advisedly attempts to effect any of the following purposes, that is to say, A, seduce any person serving in the defense force or any member of the Zambia police force from his duty and allegiance to the president, to incite any such person to commit an act of mutiny, then it goes, and is guilty of a felony and is liable to imprisonment for life. So you see, this is just an ordinary member of the citizen, right? And you find that we have a number of laws that can even follow him for what he said. But what they do to create a chilling effect, censorship among a citizen, they charge you with that provision, with that offense. And now he's serving a prison 5 years. We've appealed and we're hoping that the High Court would do justice. So maybe the question would be, how best can we, as lawyers or even just CSOs, ensure that states do not abuse such laws, where we have a number of laws that address one crime, and then they go for, depending on what is stated and the person, instead of going for a provision or a law that will attract maybe a lesser penalty, then they go for a higher penalty. How can we address that? Looking at also that we are still enacting a number of laws despite having laws that address similar issues.
Again? Okay. The problem of vagueness in the law is one of the main focuses when we are talking about legality in terms of restricting human rights. Any of you want to address the issue? Would like to? Okay.
Thank you for that feedback, Henry. I think what I forgot to mention at the end of my session was the right to appeal, and how we have a right to appeal under our national laws. So we have a right to go to court and use our national judicial system to get justice, and so get like a court judgment or a court declaration on the nature of the arrest or the attack or the surveillance, as the case may be. But all our constitutions are very clear, and I think a lot of us that are mostly Commonwealth countries, so most often the constitution is the ground norm. Like anything that violates our constitution is null and void. We need to also interrogate how these surveillance laws, all these problematic legislation are in contravention with the constitution, and it's always there. So what we need to do during our appeal, when we are utilizing our right to appeal, is that we define what the constitution is, and get the judges or the appeal judges to state that this law, this legislation, this treatment is contrary to the provisions of the constitution. Automatically that makes it null and void. But we haven't, I guess it's funding. Thank you, Media Defense, for giving us funding sometimes. But I guess it is funding that is the challenge with having to litigate a lot of these matters, and litigate on the definitions of certain terms in law and in human rights and in constitutional development and understanding our constitutions. And I think that that's an opportunity for you to use your work to probably interrogate the law using your judicial system, and allow the courts to define that some of these laws are contrary to human rights and they should actually be nullified. Shema out.
Thank you very much. I'm supporting the idea of challenging these laws through public interest litigation. I mean, challenging the constitutionality of such vague laws. Yeah, that is one of the options. But also, as I said before, UPR is another opportunity for you to assess, analyze those laws, and make sure they are part of the alternative or shadow reports you are submitting when your country is going to be reviewed, and do advocacy so that countries, peers, recommend such recommendation to the country until probably those laws are repealed or reviewed. Because this is, I mean, we've had such kind of issues in Rwanda. It's very sad. In between 2018 and 2021, I was in a court representing 3 journalists who were provisionally detained. They were facing such kind of laws. So at the end, they were acquitted by the High Court, but they spent almost 4 years behind the bars, and there is no single avenue where they could claim for probably damages for spending all those years behind the bar. So I was thinking of how can we probably advocate for like a fund that is going to be used as to compensate people who spent such kind of length of period behind the bar waiting for the justice. But also we can also look at how we can push as to make sure people, I mean, like the level of provisional detention is that low, so that people are sent to prison after they are sentenced. Otherwise, we'll still face the same challenges. Yeah, thank you.
I want to talk about the contribution of my dear, specifically in the context of Togo. In the possibility to the misuse of law to make the restriction of freedom of expression and something. And the thing we can say is in Togo, for example, you don't have the possibility to put directly a constitutionality or unconstitutionality of a law in the front of our constitutional courts. The possibility to do that is for this specific organ or organized of our country, and it is quite very important for us to have a regional mechanism like ECOWAS courts to make directly strategic litigation in front of this court, and the possibility to go in front of African Commission on Human Rights, for example, and to go at the international level. Strategic litigation can be lengthy, and that can cost a lot. But I think for the naming and shaming effect, it is important to do that. This is the first thing. The second thing is if we had a decision, they give us the tools to continue to fight against this misuse of a law, and these tools we can use this for other litigation. I think it is very important to do that.
Thank you. My name is. Okay. My name is Halima Sonda from Tanzania. As much as I agree actually with using the regional platform on holding our states accountable, but also I think we should implore on the limitation of this regional platform that have, like when we look at the African Commission for Human Rights, they can only issue recommendation that we recommend the state to do that, but most of the times we do not see the state acting on this recommendation, and it's like a regional culture of impunity, because if I'm not upholding myself, how can I be able to hold you accountable? We have seen how this have been, when you look at the East Africa region, we could see how this has been affected the whole of the region right now. When we look at Uganda, you cannot say that Museveni will be able to hold Tanzania accountable. Neither will Tanzania be able to hold their counterpart of Kenya accountable, because we could even see at the recent cases of the Boniface Mwangi, the president of Kenya could not even utter any word against Tanzania. But when we look at that, there was so much breach of the East African Treaty, but none of them they had anything to say about it. So when we say that yes, they can hold each other accountable, we might think on how we should, as a citizen, make sure that actually they are capable of holding each other accountable, because we already have a culture of impunity in all the countries, and it's benefiting the ruling class, and the power is too sweet for them actually to even say something to point fingers to another one. So we can say yes, we have platforms, but when also I look at our regional court, ECOWAS, I'm not so conversant on ECOWAS, but when you look at the East African Regional Court, when the courts are trying to use their mandate, we could see pushback from the government. There's one case, the East African Court had a ruling against Kenya, and you could see how the government, rather than acknowledge the judgment and do something right, but they were attacking the judges. There was so much pushback to the judges that it was, we actually commend the judges because they were able to hold on strong, but you could see the amount of pushback coming from the government. So I think that is one of the things that when we look at this regional platform, we must also see how best we as a citizen could have a united voice to make sure that they actually existed to help the citizen, but rather not to recommend and comment, and then we see nothing changes. My other issue is on the issue of other traditional means of surveillance, I would say. In 2024 in Tanzania, this came up on one of the UK tribunals where one of the telecommunication was able to traditionally secretful give some of the data to the government where they were able to attack on one of the major opposition leader. So this did not come out from our country, it came out from UK in a tribunal. And we were like, wow, this is happening. So we could see how much this country they are very secretive on the surveillance. And when we came to realize that it's quite a bit too late on our end as citizens to do anything about it. Thank you.
Yeah, thank you very much. Federico Links, I'm a public policy researcher. I feel we've hit the wall. All of what we're talking about has been done. The impunity, we've used the ACHPR, we've done the UPR. In Namibia, we've done it 3 times. Shadow reports around state surveillance and so on. The last one was early last year when the Namibian government appeared before the committee. Nothing changes. Court cases. It doesn't change laws. It continues. And it just gets worse. And then we see this new UN cybercrime treaty, which is going to become a problem for us because it will legitimize whatever a state rationalizes as necessary in its context. And in this sense, the Russias and the Chinas have won out because of this new treaty that will come into effect. I mean, the criticisms of it, and we've done stuff here in Namibia as well, pointing out that this is a problematic treaty. It legitimizes states' rationalizations of use of spyware and mass bulk surveillance. So I mean, these things we've been here. We've heard all this before. I've come to these forums and at FIFA Africa and others and IGFs. We hear these things. Nothing changes, folks. What next? What next?
Yes, thank you so much. My name is Ibise Luche, and thanks to Tsema for mentioning the need for us to, litigate around some of these rights that have been abused. And I'm just wondering, whether there's a role for bar associations in taking on some of these issues as part of civil society, because it could be highly prohibitive in terms of costs for you to pursue some of these challenges. What role for the bar associations?
I think what I wanted to say has really been echoed by the last two questions. So I'm only taking the mic to say, does anyone else want to ask another question so that I don't waste time? Because if no one has a different question, I'll just sort of emphasize and maybe expand upon that, what the colleague from Tanzania and Namibia said. When we're doing, and I want you to take it a little bit further than just simply reflecting on what they've asked, to sort of ask a question about hope and the point of it. And you all have experience trying to go through these channels, these platforms. And the East Africa example is really great. Dudley, I see you there. Because we've gotten to a point where even court orders by our domestic courts are merely suggestions, particularly in Kenya. It depends on the whims of politicians whether they'll comply or not. And that's not to even begin to look at the East Africa Court of Justice, and where the impunity with compliance is even worse. Not even to talk about the UPR, where it's like sometimes feels like less than a suggestion. And not to be too cynical, but you're all employing these tools, these systems. Why do you keep going in this context? And also maybe to reflect upon, recently I've been thinking more and more about the people themselves, because we're also in a global context where the traditional pressure points are basically getting dismantled on a daily basis. And so how do we put this in a context where, because it feels to me more and more like the only people that our states will actually listen to is the people. And if you look at the Kenyan context again, sorry to be so Kenya-centric in this way, but the people going to the street, the people actually saying no, feels like one of the avenues that's left. So how then do we integrate these ways that we've developed over decades of pushing back through the UPR, the ACHPR, through the courts, to what I think is the thing that's going to save us all, which is the actual people's power? Thank you. Okay.
Thank you very much. Thank you very much for sharing your thoughts. Since it is not my place as a moderator to tackle the issues, I will give the time to my colleagues to do their closing remarks and to take the opportunity, please, to address all the questions that have been posed. Okay, thank you. So we will start the other way around, or what? How would you like to do it? Ochiel?
Okay.
Okay.
Good. Thank you. Thank you.
Thank you.
I think one reason why we do it is for the record. That's something Feroz Noji said. They would file cases in the Moi regime and they'd lose all of them because, the judiciary was a department of the Office of the Attorney General. So one reason to do it is for the record. And sometimes these repressive regimes give room for the greatest change in the law. The cases that we used in Kenya, now we have developed a body of constitutional law, but the cases that we used, Kina Andrew Mujuni Mwenda, Charles Onyango Obo, Major Tinyefuza, those were cases from the dictatorship in Uganda. The case of Tula Maseko from Swaziland was also used to develop, to kill some of these statutes in Kenya. And the beauty of this is that the majority of countries here were colonized by the British. And so those colonial leftovers are common. The case of sedition in Malawi could be called abusing a public official in Kenya. We've killed that. So you can also look at what has happened in other countries. Uganda started the trend. Kenya picked it up. We've killed about 8 or so statutes through the help of media defense over the last 10 years from 2015. Criminal defamation went. Then posting obscene messages went, sending alarming messages. Someone said that a public official was corrupt. They were taken in for sending an alarming message where they're alarming the public about corruption. So you can use what has been done, including at the regional level. A lot of it has happened domestically. I think the forum to share some of the pleadings that have been done, and then you just adapt it to your local system. What I do not know is what your local jurisdiction says about the filing of constitutional claims. I think that would be more powerful than the individual appeal, because if they take in Pareg there and then you appeal for him, it only affects his case, and you're likely to lose. You're likely to lose because the offense is written in a way that the defendant cannot win. It's vague. It means anything. If the judicial officer thinks that the offense has been committed, if the police officer thinks that the offense has been, then the offense has been committed. So I think we can think about filing constitutional claims within the local system to challenge the provisions of those laws. Then you begin to see a trend where you are winning. Because when you apply the 3-part test, is it legal? Meaning, is it even defined with precision or clear? Does it have a mens rea? That offense, most time you'll find it has no mens rea. Then you ask, does it serve a legitimate aim? And then lastly, it never passes the test. Is there another less restrictive alternative? Most cases you'll find there's an alternative, like the civil tort of defamation, if the offense is meant to protect reputations. So I think let's do it for the record. Let's strategize, let's collaborate, let's see what has happened elsewhere, and then use it within our domestic systems as is suitable. Thank you so much.
Thank you very much. I think we have some realities, and we must continue to fight. We must continue to litigate. We must continue to collaborate and to share good practices to make to stop, for example, the misuse of law, to restrict freedom of expression, to spy on, to make surveillance, electronic surveillance. We must continue, and it is what we are here to share what we are doing and what we can improve our strategy to do more. I think we can continue. We have to continue. We can't stop, because it is important for us to continue to do the best.
Yeah, thank you. I will reflect first on our colleague from Tanzania. Yes, some of our, or mostly our regional mechanisms are like, there are people who call them teethless lions. Like, they just recommend, but enforcement is like, is not happening. Yes, yeah, that is the situation. But on one hand, they are working, because if you look at the constituents of those mechanisms, including probably the judges who are appointed in those mechanisms, so at the time of appointing the judges or constitute the judges or the people within the bodies, it's a time for the countries who are sending their counterparts to comply on some of the previous decisions that have been made, including meeting some of the criteria. So at the end, it will affect positively the outcome of the decisions that have been made by the mechanisms, including even the contributions. Because I remember when South Sudan was going to preside over, when the South African president was going to lead the East African community. So the first thing they were required was to contribute, to make their contributions as member of the East African community, for example. So at some point it works. But that is also why I was also opting to recommending the use of other mechanisms like UPR, because at least UPR to start with states or government committing themselves to go and do something when they accept some of the recommendations. And if someone has committed from the beginning, there is chance or hope of implementing what have been committed to. Then on other question where our colleague was saying, so since we've been doing this for so long, so until when? Let us keep pushing, because it is a battle. It is a battle, because if we do not do this, if we do not, if we abandon the battle, I think the things will be worse than even what we have now. So maybe something is being done. Yes, not at the speed we are looking or we wish, but something positive is being done, or yeah. And then on the role of the bar associations have a very big role in this fight. Why? Because, okay, if I refer to the Rwandan jurisdiction or legislations, the Rwanda Bar Association is mentioned among the bodies that are allowed to do public interest litigations. And we, litigators, most of us, we are even members of those bar associations. So bars are very big player in this battle or this game. And of course, even in the UPR process, bar associations are allowed also to come up with shadow reports and submit their submissions. Lastly, whether there is hope, yeah, there is hope. Yeah, there's hope, and that's why we are here. The speed is not that good, but opportunity will come. Things will change. Yeah.
Amen, Jean-Paul. Thank you for sharing. I understand the feelings that a lot of us have when it comes to impunity and everything. But I want to start with the Twitter ban case that the ECOWAS court ruled on. And when Nigeria had, when the state authorities had banned Twitter in Nigeria, and there was an ECOWAS court judgment. At the time the ECOWAS court judgment came, the ban had been lifted. But it was important that that judgment came because it set a precedent. And what had happened was, even with the way state actors are getting creative these days, they haven't tried to ban social media again in Nigeria, because there is a judgment that stays there. Yes, because a lot of these presidents have egos and they don't want to look like, oh, they are succumbing. They see these judgments, they act accordingly. So what they've now started to do is, becoming creative with their laws. So recently there was a conversation with the National Human Rights Commission on the content moderation law and how they want to moderate. And that's what they do. They are very creative, the state actors. It's almost like a digital and human rights whack-a-mole, I call it. It's like once there's one judgment, something else happens, then another thing raises, then you have to whack-a-mole. And so that's why we must stay on course. The human rights journey is a marathon. It's not a sprint. It is definitely a one step at it. Sometimes we don't even get judgment. I think there was one case of a murder that got all the way to the Inter-American Court, and it took years, especially when it comes to drug killings and this criminal litigation, human rights, whether it is criminal or whether it is this right to privacy, right to expression. We have to understand that it's a marathon. Also understand that these fellows are very creative. So once we even have judgments, which is why we must use our national courts very well, because it's their decisis. So if there is a national court judgment that says this and says this is contravening the provisions of the Constitution, you find that when you go to court and it starts at the lower court, you have a precedent to say this is what happened, this is what the upper court held, and this is why this judgment cannot stand. We also have to work with them in their creativity. And so if we need to name and shame, if we need to get citizens action involved, if we need to use hashtags on social media, we just have to be as creative. We cannot afford, as human rights activists, and I guess that's why we need a community, we cannot afford afford to be despondent, because we will be despondent. A lot of times it feels like you're taking 5 steps forward and 8 steps backwards. Like, we've made so much progress with law, we've made so much progress with judgments, we've made so much, and next thing, something, where are these guys thinking up these things? They have the money, they have the people, they have the communities, they have the consultants, even the private sector consultants will get involved in these things. Maybe we can also start to engage the non-state actors and the private sectors, the people that they buy this from, and say, do you know that you are breaking an international law by selling these things to these people? And start to engage them, to stop them, hit them where it hurts the most, their money. That's how you do with private sector. How do you deal with our own governments and our egoistic or egotistical leaders? We shame them. They hate being embarrassed amongst their contemporaries and even in their country. We shame them. We have to be creative as they are. I will also end with a response to your question, and I think the Nigerian Bar Association or regional national bar associations are a good avenue to shame and engage them. If we have people across board working with them and using these legal tools that we have, I think we can also leverage on those relationships. A lot of times civil society like to work in silos, and that in itself is a problem. Sometimes we don't even see how the lawyers come in handy and how we can use litigation and how we can use these actors. But maybe we need to start having, I will confess, even myself, most times I don't remember to invite the bar associations to conversations. The last time when we had like a journalist who was arrested and he was taken away, I didn't even see the need to use the bar association, even just to quickly file an injunction to stop those processes. We don't think about it. We're not creative enough. And so, yes, we received that feedback. We should engage more with bar associations. They are very critical to ensuring the speed of this, especially because the money might not be there. But I will also implore us to be very, very creative. We cannot afford to be despondent. I appeal to us. We cannot, because human rights work is a lonesome, thankless job, but we must stay on course for the next generation. And things are bad, but were they as bad as they were? Every time there's a new law that stops them, there's a new law that stops them. So we get creative, they get creative, we get creative, they get creative. We just continue on the creativity loop until we reach Uhuru, if that ever exists. So yeah, I'll end with that.
Thank you. Where can I sign every word you have said right now? Like I totally 100% agree with you. Tsema, we are coming to an end of this panel. I understand the frustration. I totally do. I've been working in human rights like for more than 15 years, and sometimes I will be dealing with cases that came to me and the victim had lodged the application 20 or 25 years ago. And I had luck that the victim was, 85 years old and still was alive. So it takes time. It takes like it's a long battle. It's very slow, but that doesn't mean it doesn't work. And I will just close up with some of the examples at the region. Take, for example, like the decriminalization of defamation laws. Take an example at Zimbabwe, South Africa, Malawi. Take a look at their constitutional courts. They have decriminalized defamation law. And that's a trend that started, 30 years ago, 40, I'm not sure, but it started like way long ago. So it takes time. It takes more time that we would wish to, but at the end, sometimes it works. So I would encourage you not to lose hope, as my colleague said, and keep on fighting. So again, thank you very much to my colleagues. The insightful views you gave us today, and also, of course, this beautiful and very engaging audience. Thank you very much. See you in a bit. If you want to swing by to our stand, we will be there. Thank you very much.